order. This is meeting number 18 of the Standing Committee on International Trade. Today we have the Minister with us for the first hour, and the second hour we will continue our study on forced labor. So pursuant to Standing Order 1082 and the motion adopted by the Committee on Thursday, September 18, 2025, the Committee is resuming its study of Canada and the forthcoming CUSMA review. We have with us today the Honourable Melanie Joly, Minister of Industry, and from the Department of Industry, we have Francis Bilodeau, Associate Deputy Minister, Innovation, Science and Economic Development. Welcome. And Kendall Hembroff, Associate Assistant Deputy Minister of the Industry Sector. So thank you all very much. We appreciate you being here. Minister, you have 5 minutes or so for your opening remarks, and then we will go on to our usual questions, which will be 5 minutes tight for all of us so that all of the members can make sure that they get their questions in. So if we can have kind of limited answers too, because otherwise you eat up all of the members' time, as you know. You remember in those days when you were on the other side. So thank you very much for being here. I'll turn the time over to you.
Thank you, Judy. Madam Chair, honorable members, it's a pleasure to be here. Merci d'être ici. Canada enters this CUSMA review at a time of profound global change. We're living in a much more complicated, complex and dangerous world. The security environment of the world has deteriorated over the last few years with wars, but also through increased economic tensions, including the current trade war with the United States. And this will continue to be our government's reality. Nous savons qu'il y a des choses que nous ne pouvons pas contrôler.
We know that there are things that we cannot control, but there are many other things that we can control.
What we can control. Here's the plan. First, we'll protect jobs. Second, we'll create jobs. And third, we'll attract talent and investment. And our plan is working. We're seeing 2.6% growth, tracking to be the highest in the G7. Inflation has come down to 2.2%. Wages are up to 3.5% year over year. And in September alone, we created 60,000 jobs, and in October, we created 67,000 jobs. Ces résultats montrent que notre plan produit des
These results show that our plan is creating concrete results for our economy and for Canadians. The Canadian economy is resilient, but we're continuing to work ceaselessly for our people.
Protect jobs and protect industries. We're working in a reality where we know that we have certain sectors that are the target of the American tariffs. And of course, we're talking about steel, aluminum, auto, and lumber, industries that are vital to our economic strength and to our communities across the country. And here's what we're going to do for all of these sectors. In the short term, we'll protect our market and we'll offer liquidity to companies. We'll make sure that we support industries and the businesses and the workers in these sectors. And so we did so by tightening the tariff rate quotas on steel imports to 75% of the 2024 levels, a decisive step to protect our market in the short term and ensure the steel sector is protected. In the medium term, we need to make sure that industries can adapt and pivot. They need to be able to seek out new markets, and they need to be able to develop new products. Et nous soutenons nos industries grâce à un nouveau fonds de réponse.
Industries, because we have a new strategic response fund of $5 billion, and also we have local or provincial economic development agencies. So we have to work to create a domestic market. Our government does it thanks to investments in defense, also our policies of buying Canadian, and also strategies in terms of housing, and also the major projects.
When I talk about Stellantis, I mean the Dodge Caravan, the Jeep Grand Cherokee, the Jeep Compass, the Jeep Wrangler, the Chrysler Pacifica. And I was clear at my committee appearance at Indu, Stellantis is on the hook. Within a day of Stellantis announcements on October 15th, I sent a letter to Antonio Filosa, the global CEO of Stellantis, stating that the company's actions were unacceptable and that we expected them to honor their legally binding commitments to the Government of Canada. On October 20th, I summoned Jeff Hines, the then Canadian CEO of Stellantis, for a meeting in Ottawa, joined by Vic Fideli, Ontario's Minister of Economic Development, and Lana Payne, National President of Unifor. On October 23rd, Together with the Minister of Finance, we announced a 50% reduction in Stellantis' annual remission quota. That means Stellantis has 50% less of a market for its cars without tariffs in our country. On October 30th, I went to Brampton to meet with the strong men and women who build the backbone of Canada's auto industry to let them know that we'll always fight for them. On November 3rd, I triggered the formal dispute resolution process under the contracts. And today, on December 4th, I'm formally announcing that we're serving Stellantis with a notice of default under the contracts. When it comes to protecting auto jobs, we will not let these industries down. We'll stand firm for the sake of our workers, our industries, and our nation, because defending these jobs means defending Canada's economic backbone and the livelihoods of countless families. Now, I've talked to you about the first pillar, which was protecting jobs. Let me talk to you about the second pillar, which is create jobs. And create jobs, and of course, beyond this, create industries. In every single crisis, there's an opportunity, and we need to act with audacity, purpose, and determination. While we know some things are beyond our control, creating jobs is really what we can do. And so what we're doing right now is we're investing in defense through a defense industrial strategy. We're also investing in major projects across the country. Meanwhile, what we will continue to do is to make sure that we can support our demand for steel, for aluminum, for housing, for lumber. We can do that through, obviously, the Buy Canadian policies and the housing policy that we've put forward. Finally, our third part of the plan, which is to attract. Le troisième pilier du plan, c'est attirer.
Part of the plan is to attract investment, attract talent. And we've started already to attract talent. So we have $1.7 billion to attract 1,000 new talents and 1,000 researchers in Canada. And we're also working to attract investment. And that's why I was able to travel throughout Europe and in Asia to be able to attract new investment and protect sectors that are being targeted by our tariffs.
And of course, I've had the chance to have many discussions already at the Indo Committee in the House of Commons, and I look forward to having a conversation. Thank you so much.
Very much, Minister. On for 6 minutes, Mr. Chambers.
Thank you, Madam Chair. Minister, welcome to committee. Thank you for joining us this afternoon. You mentioned Stellantis, so we might as well start there with the auto sector. Were you concerned when you saw the testimony last week from your officials that indicated that no one person read the contract front to back before that was signed?
Well, first and foremost, I think we have to put things in context. If you look actually at what was discussed and what my deputy minister at the time said, is that he was not involved in the redaction of the contract, nor was I, of course, because we were not in our positions at the time. As you know, the contract was signed some years ago, and you were not in your position neither. Now, what is clear is we both since then read the contract, and of course I can answer any questions
wonderful.
about that.
When was it that you read the contract?
Well, when the issue...
was it last week? Was it 2 years ago?
years
Obviously,
ago,
it wasn't 2 years ago because you weren't there, but when did you read it?
So when the issue of Stellantis became really important, which was around October 15...
So you read it?
Of course I read that contract because we got a 24 hours heads up from the global CEO saying that they were moving the Brampton Jeep model, well, the Jeep Compass model,
right,
to the U.S. And we thought that that was completely unacceptable. So we got to it, and we found very quickly how to make sure that Stellantis was on the hook.
The testimony last week was that during the contract negotiations, no single person had a view on that contract cover to cover. Does that concern you?
To be frank, it doesn't.
Well, that was the...
No, but like, you can't negotiate a contract without reading it. That doesn't make sense. Like, just listen to what you're saying.
I don't know. The deputy minister said that the individuals involved would not have had full view of the contract. That was the testimony.
There were many contracts that were involved, okay. All of those that are already, not only are they available right now, Adam, but they were available 2 years ago, and the opposition, so basically the Conservative Party, had access to it. And you guys
Well, no,
also
that's
read
not
the
true. I
contract.
think they're just getting
so
them,
there's
you
nothing
know.
new here.
That's okay. So now that you've read the contract, that's fine. You've
Yeah.
read the contract. Were you concerned that the jobs guarantee in that contract, or are you satisfied with the jobs guarantee in the contract? Is it anything less than 100% of Stellantis' footprint at the contract was signed?
See, you know what was my reaction when we got the news from Stellantis? My reaction was, we can't open that floodgate of basically our automakers leaving the country. That was my reaction. And my reaction was also to make sure that everybody around this table is one Team Canada, because we're all fighting for the 125,000 jobs in the auto sector. And so I was in fighting mode, and I was finding how to make sure that we would make Stellantis on the hook. What was clear in that contract is that the investments in the battery plants, which are super important, which we stand for and will continue to defend, were linked to the Brampton facility.
Okay.
And that's why we say it's on the hook.
On October 21st, you said in the House, the opposition on the committee will have access to the contracts. They will discover that we indeed negotiated well. Do you recall saying that?
I stand by it.
Okay. The jobs guarantee in the contract, is it for anything less than 100% of Stellantis' footprint at the time the contracts were signed?
See, what is happening is when you're dealing with an automaker, you know that there will be...
Minister, you're negotiating a contract.
I didn't negotiate the contract, but what I can tell you is that when you look at an automaker over a 10, 15-year period, you know that there will be changes in models. And sometimes during that time, that, lifespan, there will be time where basically there's retooling and that basically people are put on pause to then, of course, being rehired. And that is all negotiated with Unifor. That is all negotiated with the unions. And so that is why it was really, really important to have a job number. But what was most important, Adam, and that's my last point, it was to link the protection of Brampton. Because there was a preoccupation at the time, and I wasn't there, you weren't there, but there was a preoccupation to make sure that we would protect the jobs at Brampton.
Is the jobs guarantee in the contract for less than 100% of Stellantis' footprint at the time the contracts were signed?
Listen, what I can tell you is that there's a job guarantee, and what I can tell you also
So there
is
is
that
a job guarantee, but it's for less than 100%.
For once, there was a link between the new funding that was given to create new jobs in Windsor to the Brampton plant.
So for anything
and
less...
that was really, really important because when you look at it, and we learned from 2009 what the Conservatives did at the time. At the time, there was no job guarantee. So we made sure that that was the case.
Are there executive compensation restrictions like there were in 2009? Was there equity given to the government like there was in 2009? I'm sorry, Minister, but you can't compare those. And plus, that was 15 years ago.
Well, no, I think that they were in
15 years ago.
You are comparing
and you've negotiated,
the same
your
type
government
of
negotiated.
Mr. Chair, the translation is not good because we have
Minister,
two persons in the
your
same
government
time.
negotiated. It sounds like your government negotiated a $15 billion corporate subsidy to Stellantis without 100% jobs guarantee for the footprint of Stellantis at that time.
I think you're mixing up
That's what it
things.
sounds like.
To be frank, you're mixing up things, okay?
So
in 2009,
will you say what
please,
the percent of the? Will you say
Madam
what the
Chair,
percentage?
I just want to be able to answer.
Let her finish because your time is up, and I want everybody to have a shot here today.
Yeah, of course.
Minister?
In 2009, when you negotiated and shook hands with GM and Chrysler at the time, there was no job guarantees, and following that, the Oshawa plant was closed for GM. The Windsor plant for GM was closed. The Ford assembly plant following that was closed, and the Orion bus assembly plant in Mississauga was closed. It was devastation. And we were the first government to bring back jobs in the auto sector because we were able to create around 3,000 jobs in Windsor, and we were able to create around 3,000 jobs in St. Thomas. So it was really good investments.
Thank you, Minister.
Thank you.
Madame Lapointe, please, for 6 minutes.
Merci beaucoup, Madame la Présidente.
Thank you very much, Chair. Welcome, Minister Joly. I'm very happy that you're with us today. In 2018, there was the renegotiation of CUSMA, And you were already involved, Minister, and I remember that there were issues in terms of the acceptance for culture and protection of French. So we're looking at what's happening in Montreal, where culture's industry is very important. So can you explain the alignment of government on these very sensitive issues in Quebec and for all francophones outside of Quebec? Thank you. So the cultural exception is very important, especially in the renegotiation of CUSMA and for all our free trade agreements. So we put it in all our free trade agreements, but also we're part of the Convention on Cultural Diversity of UNESCO, which is very important, which is really our anchor in order to negotiate cultural exceptions. It's important because it allows the government after that to create legislation to protect our culture, to make the necessary investment without form of retaliation on the part of the U.S. and Mexico in this case, to support the Canadian Media Fund, Radio-Canada, CBC, National Film Board, and Telefilm. So yes, and every time I work with the Heritage Minister, the Minister of Canadian Culture and Identity. Thank you for that explanation. You know that my county is in the Lower Laurentians, and the aerospace industry is in Montreal, but also there's a lot in the Lower Laurentians. And Quebec has a strong concentration of businesses in aerospace, energy, and food technology and energy sector. So how will these sectors be protected in the next form of the free trade agreement? Well, those sectors will have an advantage because the supply chains between countries in the aerospace industry involves Canada, the U.S., and Canada. We see that American companies have invested in the Lower Laurentians, so Textron, Esquires, and we also think Bombardier, that they have plants in the U.S., so we know that everything is integrated and coordinated. But I would also add that it's not necessarily linked to CUSMA review, but it's related to our will to manage the consequences of these tariffs. So we're creating a strategy for defense, and we think that the aerospace industry will be a big winner because our basic rule in the strategy is to build in Canada. And so when we have a major procurement for defense, our objective will be to create jobs in Canada and to build plants in Quebec as well. So that'll be good news for my region to know that will ensure that defense investment also bear fruit in our part of the country, which I know very well. How does the government intend to use the review to increase the competitiveness in our sector? Canada is the only country of the G7 to have a free trade agreement with all other G7 countries. And the Minister of International Trade could give you more information on the free trade agreements that we have with other countries. It's quite high. When I meet companies wishing to invest in Canada, because I'm also responsible for investment made in Canada, our access to various markets in the world is an advantage for us that's very convincing. So in those circumstances, I think it will help our competitiveness. And there are different measures in the budget, including tax credits, that are very positive for attracting investment. But to come back to CUSMA, our goal will have to be to continue to have access to the American market and the Mexican market, knowing that we have some sectors that are targeted by tariffs that are unjustified, and we have to look after that, and that's my job, and it's part of my functions. I received questions in terms of industries that work in steel processing, and they we're talking about problems causing them these unjustified tariffs of 50% and 25%. What can I tell them? Well, they're right to say they're unjustifiable. They're direct victims of these tariffs. The way I see things, if we're in a trade war, the battle is on the economy, and the front lines are the sectors that are touched. In Quebec, it's aluminum, steel. Throughout the country, in Ontario, it's very much the automobile sector. And we know that softwood hurts everywhere, or is hurting everywhere in many regions in the country, certainly in Quebec. So my job is to be able to support people who are on the front lines, to help those entrepreneurs who are very, very concerned because they have to manage the impact of the tariffs. So they have to diversify their exports greatly and develop new products. And my role is to help them to adapt and to pivot. So it's a task that's demanding, but we had the population that gives the mandate to do this.
Please, for 6 minutes.
Thank you, Madam Chair, and thank you to be here, Madam Minister, and also to your officials who are here. I wasn't going to ask this question, but my colleague mentioned culture, gave me the idea. So with the cultural exception, we'll keep it completely. Maybe you won't be the only one acting on that, but there's do you think that they might invoke the reprisals clause, or is there an exemption from that? Will it be total, or will it be only an exception chapter by chapter, as with Europe? Well, I'm not in charge of bargaining. The Prime Minister is in charge of this, and he's supported by Minister Leblanc. But what I can tell you is that as a Quebec MP and a Quebec Minister, for me, it's important to be able to protect in the free trade agreement that cultural exception, and the Prime Minister mentioned it in his election campaign and committed that this be protected. So you would be very favorable for there not being any reprisals provisions. Well, I don't know enough about what you're telling me, and I don't want to mislead you as to what's being currently discussed at the table. Oh, that's good. No, that's I'm fine with that answer. So in terms of culture, let's go from culture to agriculture. We had Minister Leblanc here. He said there will be no harming supply management, and can't do it through the back door either. Yes, that's our position, and we also affirmed that in our election campaign, and my colleague said it. He's the one who's working with the Prime Minister and who's in charge of that, so I agree with him. So we can't get around through the back door. No, we always already worked to develop something with the Bloc Québécois. And speaking about softwood, I don't have in my writing, well, I have little trees, but there's no forest industry. Yes, it would be sad not to have any trees. But we're talking about total tariffs that go beyond 45%, and that's very, very serious for the industry. Can we expect a specific strategy for the softwood industry? I know that my colleague Tim Hutchison, the Minister of Natural Resources and Energy, is working not only to put into place the plan that we have to support the softwood sector and the forest industry more generally, but also to have a plan to help businesses adapt and pivot. It's sure that it's a provincial jurisdiction, a Quebec jurisdiction, but also from the federal government. So we're there to provide support to attenuate or mitigate the effect of the tariffs. We worked with the BDC to offer a solution to banks. So banks are offering solutions, but the risks are assumed by the government and by BDC. So that's the approach we're using. And I imagine that my colleague has worked with the provinces as well, because we know that the logging rights and everything is provincial jurisdiction. Yes, so this is global for everything. It's not specific to softwood. Well, the BDC help is specifically for softwood, and it's accessible. Yes, it is, and I'm hoping that the banks will go even further. I think that the problem that we see in softwood currently is that we're talking about taking more risks and going more into debt, but banks are very allergic to risks. So we created a solution that would allow banks to take these risks because we're assuming the risk. So we want to ensure that businesses in softwood lumber don't go into a spiral of debt. So that's why we have a specific approach, and that's why I want banks to be able to pay out more quickly. So is it really loans that are the best strategy for this? It doesn't seem to be. It's not a subsidy. We think that this approach for softwood via the BDC, so offering liquidity, and for processors, we also have help from the regional economic development agencies. And in that help, there's a part of it that's not reimbursable. And that policy by Canadian that was announced on September 5th, we're talking about prioritizing Canadian raw materials in federal contracts, so 25 million. And on November 9th, we heard the intention to implement that policy towards the end of 2025. Yes, we had to have the budget accepted. We still need a few important votes to do that, and I hope we can count on the Bloc for the budget. I won't say anything at this point, so I can represent you as a lawyer. So that's it. So can we expect this before the end of the year? Supposing everything goes well, the implementation will be progressive. So there are already measures that have been taken, but this will happen in the first and second quarter of 2026 for buying Canadian. Thank you, Madam Chair. Thank you to our guests for being here. Madam Minister, thank you for being here with us. I would like to talk to you about the American tariffs. I'm from Beauce. We're near the U.S., and we do a lot of business with the Americans, and we've been attacked very hard in steel and in wood. I made an economic trip in Montreal and in Beauce. I'm an entrepreneur. I understand the issues. I understand the concerns of these businesses. Madam Minister, none of these businesses wants funds from the Canadians. They just want to deal with the Americans. Yes, I understand. I've met a lot of entrepreneurs, and I understand the situation currently, and I can see it because I also make visits everywhere, especially through Quebec, because I'm in charge of regional economic development in Quebec, but also all over the country. And one thing is clear. When I meet people in the affected sectors, I know that there is an anxiety, but I know that they also know that the American president and the American administration is very unpredictable. And they know that we're there to help them to pivot, because regardless of what might happen, there can always be unpredictability, uncertainty. And we know that in business, what is the most frustrating is risk management. And geopolitical risk is currently omnipresent. And that's why we offer help, we offer some equity, and we try to control what we can control. So I've met several entrepreneurs in Beauce. They have told me they want to be able to sell more in Canada and the rest of Canada, and also to France and to the European Union. But you can't pivot. You can't do that in 2 days or 2 years even. I know that. And I know that Beauce is on the American border, so there's a very high dependence on the American market. But we will work with those entrepreneurs to go to other markets. So in terms of programs like Buy Canadian, all that, you have to have a business that's that does about $2 million to make business. So why do you only encourage the large factories? $2 million? It's a major industry, but it's still a small or large industry. Ask those questions to the Chamber of Commerce. So why do the smaller ones not have access to that program? So I'd be happy to work with you, Jason, to see if there are businesses in particular that are having problems. We can find solutions in these sectors that are hit by tariffs. These are there are many of these industries, so I think you know the regions. You come to Beauce from time to time. I'll take as an example the center of Quebec or Chaudière-Appalaches and Saguenay. I know those people. In addition to American tariffs, there's one other thing they talk about constantly. It's labor. They don't have enough labor. We have the lowest unemployment rate in Canada. We proposed renewing the temporary foreign worker proportion below 5.5%. There's something in the budget that hasn't been explained. They're just waiting for you to explain what's happening there, and it's up to you to control that. The Prime Minister is certainly aware of this. He's working with the businesses that are involved. I've heard about this concern in the regions also when I was in the rural regions. I hope we can work with the Conservative Party. When the opposition leader came, he said he was against temporary foreign workers. So people were shocked. So 5.5% unemployment. I don't want to play politics here, but we need those people. So I'm just asking you, when can we have the answer that we can give to our businesses? My goal is to be able to work with you, with colleagues, so that it can happen, because I know that it's important. I hear it. When I go in Trois-Rivières in Quebec, I was in Saguenay-Lac-Saint-Jean on several occasions, because it's a region that's been strongly affected because of aluminum. I have friends and acquaintances who are in business, and I hear about it, and we're in the work of developing solutions, and we'll work at this. But it's very dangerous to politicize the file of temporary foreign workers, and I find it really too bad that the leader of the opposition did this.
A fighter, and we can see it, we can feel it in your words, in the way that you speak about how you're protecting workers. I feel it. Mm-hmm. And you started your remarks by talking about how important it is to be Team Canada, to be united. And I hear this everywhere. I hear it in my community. They'll speak, you know what, this is what I'll hear. I like when the Liberals and the Conservatives, NDP, Green Party, everybody working together, understanding how big a threat this is. People know that. And they want to see everybody working together. And that is imperative. That is probably the best tool. We could talk about Buy Canadian, the Strategic Response Fund, our diversification. But the number one thing we have is keeping Canadians united as Team Canada, understanding this. And thank you for doing the job that you're doing on that. And that's my question, is that you go to the front lines. You were talking about, meeting with Unifor, Lana Payne, bringing in, the CEOs, having everybody at the table, understanding that we got to get to the right solution, the right deal. Can you tell me how you work through that process, how you meet with the front lines, how you get that message across?
So different ways. I must say, my department is very much in solution mode, because we get so many companies coming to see us, businesses, entrepreneurs, wanting either to get help because they're in the tariff sector, the sectors that are impacted by the tariffs, or want to adapt and pivot and or invest. The difference is quite stark, because we're the only country right now of the G7 that has zero tariff overall on our economy. I was just in Japan and Korea. They both have 15% tariffs. We know that that's the case for the EU. We know that, UK is 10%. And so on certain sectors, things are going well, actually, and our plan is working. And I just mentioned 67,000 jobs created in October, 60,000 the month before in September. But in the sectors that are impacted by the tariffs, the pain is real. And so we provide the information to the negotiating team with what are the impacts of the tariffs, what are basically our different sectors that are under us, which are, many, many different sectors, except from basically natural resources and energy. And that's how the Prime Minister and Dominic LeBlanc, Minister LeBlanc, and the clerk and the chief of staff, also the Prime Minister, are able, and Kirsten Hellman, our ambassador to the U.S., are able to negotiate. So a lot of the information actually provides, it's basically market information that we have that is provided to the negotiators.
Thank you. And what I also hear on the street is people want to buy Canadian. They want to make sure. But at a bigger level, when we're looking at some of our infrastructure or building our homes, our Build Canada Homes program, how does your office work with industry to be able to have them retool or change kind of their business dynamic to be able to take this opportunity and be able to grow our country?
So I'll give you the example of steel. And we haven't talked about it, but, the only Canadian steel plant that is Canadian-owned is actually Algoma. And we were very, very preoccupied with what was going on at Algoma, even before the tariffs. And, then it became 25% tariffs and eventually became 50% tariffs. So I was making calls to Seaspan, the shipyard in Vancouver, that is actually part of our national shipbuilding strategy, to make sure that they would be taking orders, and making sure that they're buying steel out of Algoma. I was calling Jim Irving at Irving Shipyard and meeting also with the CEO in Halifax to make sure that they would be also buying from Algoma. Really working with the FASCO in Hamilton also with new projects to have steel cans and different ways to be able for them to be making the right type of steel. One thing that is really, really important to remember when it comes to the steel sector is the entire business model has been developed on supporting the U.S. automakers on the other side of the border. And that business plan doesn't work anymore with 50% tariffs. And by the way, the 50% tariffs are all on the steel industries around the world. And so that is why it's really important right now, and I'm heading to Algoma in the coming days, to meet the workers, to meet the union, to meet also the leadership team, that they
Thank
be
you
able.
very, Minister. I'm sorry to interrupt. Thank you very much. Savard Tremblay for 2.5, please.
Oui, merci. En fait,
Thank you. Well, maybe we'll go back to what we were talking about on the Buy Canadian program. Do you see that there's opposition or fear on the American side? So I'm not negotiating every day, but I haven't heard any concerns. You have to remember that the Americans themselves have protectionist legislation in terms of procurement. Yes, for their businesses, but probably they would like that their businesses continue to benefit from business. No, I'm not speaking personally about the American administration, but you have not experienced any pressure, and you don't think this would harm negotiations? As a former foreign affairs minister, I continue to follow developments in geopolitics because there's a relationship between my job of being in charge of the economy in Canada and what's happening in the world. And protectionist policies are emerging everywhere in the world these days. That's why I had discussions with the European Minister of Economy, Stéphane Séjourné, to know how, while they want to protect their steel market, how we could work with them so that we can continue to have free trade despite the environment of protectionism. Things are developing so quickly that we're trying not only to negotiate, but also to diversify our markets and to draft new rules, because the international commercial rules are no longer working on another topic, on an idea of harmonization, and this idea of Chinese EVs. So harmonize the tariffs we have there. So we increased them, Canada increased them about a year ago. So it's now 100% like it is for the U.S. Is that still something that we need to do? We're not thinking of changing that, because Mexico also increased them by 50%. So could we use that in negotiations, even though you're not negotiating? You yourself? No, I won't make any hypotheses here for you. But one thing is clear. We have to protect our automobile sector, because tariffs of 25% that are touching 125,000 jobs has an effect on Ontario. And if Ontario is affected, the Quebec economy is also affected. The economy of the whole country is. So it's very important for me that we can defend that sector.
So in your opening statement, you referred to steel, lumber, and our other critical sectors. So steel, aluminum, autos, lumber. My understanding is that those tariffs that are imposed by the U.S. are done so under the Trade Expansion Act of 1962, Section 232, and then in the case of lumber, additionally anti-dumping and countervailing duties. Is that correct? Do I have that right?
Well, yeah, it's a fact. There's also a presidential, an executive order for fentanyl. Fentanyl-related tariffs under the IEEPA.
And those would be the IEEPA tariffs.
Exactly, but they're on pause.
Right. And so you're following the court case in the United States, Voss Selections, which is dealing with the IEEPA tariffs?
I am, but as MP, like you, because I'm not in charge of the negotiation.
So my understanding, and I hope this is yours as well, as we've just established, if the Supreme Court in the United States strikes down the IEEPA tariff, that will provide no relief to the industries I just mentioned. Is that correct? Because those tariffs are imposed under different laws in the U.S.
My job here is not to make any form of hypothesis, neither...
It's not a hypothesis, it's just fact, and your job here is to speak on behalf of these industries, so I just want to know, what's your understanding of that? And if you don't know, that's problematic, so...
Jacob,
yes
please,
or no?
Can you...
Give the minister time to answer.
Yeah.
Please.
So...
If she answers, yeah.
I always answer.
Respond.
I think that there's a lot of, as I said in French, many unpredictability linked to this administration. The U.S. Supreme Court decision is obviously something that the negotiating team is following, and I must say, the entire world is following.
Know what effect that will have.
Obviously, I won't, in front of this committee, develop any form of strategy or tactics that the government could take. I think that overall, we should work as one Team Canada to see what could be the impacts eventually. But I'm not here to make any form of, how can I say, analysis on what could be the impact on Canada or the world.
I guess I would suggest it's concerning that the industry minister has no analysis of what will happen if that's the case.
No, I'm sorry, but...
Then tell me what your view is then.
My job is to help the sectors here in Canada while the negotiating team is negotiating, and they have also their own strategies. And obviously the world is following what's going on in the U.S. every single day. We were following what was going on in Tennessee yesterday. We're following what's going on in Miami at the electoral. So we have a team, and I'm talking here, I used to be in charge of foreign affairs, so I know that we have a fantastic embassy in the U.S.
Thank you,
and
Minister.
They're doing that.
I'm going to move on because I have
day.
limited time. I appreciate that. Obviously, a large part of our bilateral trade is defense production with the United States. A few weeks ago, in response to questions about the F-35, you made comments that you said you didn't believe there had been enough jobs created or industrial benefits out of the F-35 program. You repeated that yesterday, actually. And then in response, Ambassador Hoekstra made some comments suggesting that that was an impediment to our trade negotiations. You, as you said, were foreign minister. You were at the very first party at Mar-a-Lago with the president. If anyone should have known that injecting uncertainty into the F-35 deal would piss off the Americans, I would have thought it was you. So my question is, why would you do that at the 11th hour? Why inject uncertainty into this negotiation?
A couple of things. I was not there at the first party at Mar-a-Lago, so your facts are wrong. Second, we took a decision following the imposition of tariffs against us, which I think Canadians support. My question to you is, do you support or not the decision of putting on pause the F-35 contract? Yes or no?
I'm asking you questions, not
well,
the other way around.
I'm asking you questions. Goes both ways.
No, it doesn't.
Yes,
actually.
It does.
Not at committee.
Well,
this
you
morning,
know, this is parliament. This is part of parliamentary committee. This
I'm just
is
asking
democracy.
you why you did that.
But Jacob, yes or no? Is that the position of the Conservative
okay.
Party? Yes or no?
At the Defense Committee this morning, the Minister of National Defense said the F-35 review was his file, and he said he was reviewing it, quote, at the request of the Prime Minister. Did the Prime Minister ask you to review that as well?
I'm in charge of industrial benefits for defense contract. That's the role of
So you are reviewing the F-35 as well?
For industrial benefits, of course. Yes, absolutely. And that's why I think we didn't get enough and we need more. And I hope the Conservative Party is in favor of that. If not, you know, we want to know.
Thank you very much. On to Mr. Lavoie, please. The floor is yours.
Merci, Madame la Présidente.
Thank you, Madam Chair. Hello, everyone. I'm sorry that I'm not there today, but I needed to be in my riding. Hello, Minister. I'm very happy to have you here with us today. And I have two questions to ask you, and I'll ask them one after the other and give you the time to respond. You know my story. I worked in banks for many years for funding businesses. What I noticed a lot is that we were funding all sectors of the economy. In all sectors, there are ups and downs. They're a bit like cycles, and often the best businesses, what happened when things were going badly in their field, they would invest, and then they could do better. And so I'm comparing with the situation currently. Things are going badly. We have tariffs. Things are not going well. But I'm seeing that there are several businesses have considered that it was a good time for them to invest currently so that when we get out of this crisis, they might be the best on the market. So my first question is, how can EDC support them currently with subsidies and investment so that they can take advantage of this time to increase their productivity? And my second question, briefly, you know, I'm MP for Beauport-Limoilou. We have the Quebec port that's in my backyard. It really is. And you were in Japan recently. You're talking to people in Japan who are saying, listen, people want to do business with us. It's time. So I'm now wearing my deputy hat for my riding because we have strategic infrastructure right near us and wonderful businesses. My second question is, how can we, with external markets, foreign markets, take advantage of our structure and have our Beauport-Limoilou businesses do well? Thank you, Steve. For the first question, we have many, many different programs for support. The biggest one is the Strategic Response Fund. So there's a $5 billion fund, which includes the former Strategic Investment Fund that was often used, the SIF, and that was to attract investment, especially from abroad, or help Canadian businesses to adapt and pivot. But now we decided to offer this funding to sectors that have been the victims of tariffs. So this $5 billion is very important. It allows businesses, such as those of in the sector of steel or also aluminum, to start manufacturing aluminum that will be responding to our domestic requirements, including defense. So usually what we do is send it to the U.S. and it comes back in a processed form. So that's part of the discussions I'm having with the major players in aluminum and also with smaller businesses. We also help businesses in the aluminum sector to export their products. If we look at Alouette, first trimester, 4% of their production went to Europe, and second quarter, 52% of their production of this smelter went to Europe. So that's also a part of the programs for the offers we make to these companies affected by tariffs. So the major players have access to the Strategic Response Fund, and the smaller players have access to EDC for Quebec regions, ADEC. And this is related to the question that Jason asked me. And there's a part of it that's non-reimbursable. So we know that small businesses often are not as strong economically than the bigger players. And there's a fund that's dedicated to SMEs that are affected. And for softwood, there are other programs that are offered, and I already answered those questions when Simon Pierre asked me about the softwood lumber field. And finally, yes, there is an interest for Canada. Canada is very well rated because we're perceived as a country that's able to, in spite of everything, manage the dynamic with the Americans quite well in a very difficult situation where within Western democracy, the question is how to manage this relationship with the U.S.
Merci beaucoup, Madame la Ministre. Merci à vous, merci à vos fonctionnaires. Nous allons prendre quelques instants pour...
There's nobody over there. That's too bad for them. All right. Again, calling the meeting back to order pursuant to Standing Order 1082 and the motion adopted by the committee on Thursday, September 18th. The committee is resuming a study on the Canadian supply chains, forced labor, and related imports. We have with us today as an individual Sabrina Bendali, partner and head international trade and investment practice, Stephen Pike, partner, and Sean Stevenson, counsel. Welcome to you all. We appreciate you taking the time to be with us today. Ms. Bendali, I will give the floor to you for up to 5 minutes, please.
Thank you, Madam Chair and members of the committee. We appreciate the opportunity to appear before you. I am speaking to you today in my personal capacity and not on behalf of my firm or any specific clients. That said, my views are informed by my experience advising companies with respect to supply chain compliance, including companies who have faced detentions on grounds of possible forced labor in their supply chains. While I cannot comment on the details of specific cases, these experiences have allowed me to observe firsthand some of the difficulties that the design of our current law, based on tariff classification, creates from an enforcement and compliance perspective. So I will focus my comments on explaining some of those challenges and the need to ensure that the obligations of importers are reasonable and practical. Eradicating forced labor and child labor from supply chains is an important goal. But presently, importers are left without adequate support or clear expectations about what, concretely, they must do in order to be able to confidently import goods into Canada. Parliament implemented our prohibition on importing goods made with forced labor or child labor, in whole or in part, by defining these goods as prohibited goods classified under Tariff Item 98970000. But the rules and compliance obligations that apply in the context of tariff classification create challenges when addressing concerns about the use of prohibited forms of labor in supply chains. Tariff classification is classically analyzed in rem, meaning that it is based on the good itself as it appears at the time of importation into Canada. Most commonly, this means that you can examine the good and determine its correct classification based on its physical characteristics, material composition, or function. In most cases, when tariff classification is based on factors that are not evident from the good itself, like conditional relief items, for example, that are based on a specific end use, the record-keeping regulations that we have explicitly state what documentation is required in order to prove eligibility. But establishing whether there's forced labor in supply chains presents different considerations. It requires information about the production and upstream sourcing of raw materials and components that may be many degrees removed from the good that is imported into Canada. And because the legal mechanism that's used is tariff classification, this potentially creates a strict liability obligation that may not always take into consideration whether the non-compliance was willful or the reasonableness of the compliance burden in the first place. Importers likely may not know all of their suppliers, let alone have access to reliable information about their labor practices. Supply chain information may be considered confidential and competitively sensitive, and upstream suppliers may be hesitant to disclose information and records to their customers. Effectively, the law has the potential to expose importers to legal risk, including possible criminal risk, as a result of conduct over which they may have little or no visibility, control, or influence. In the early detention cases, we have seen that tension play out. The CBSA identifies shipments for detention based on confidential intelligence about the alleged conduct of parties in the supply chain, or allegations about an industry or geography in which some part of the goods are produced. The risks identified may not arise from the immediate supplier with which the importer has a direct relationship, but from farther up the chain. If the CBSA has a suspicion that goods are made with forced labor, it may detain the goods and notify the importer to demand information and documentation about the complete supply chain, all the way back to raw materials, within 30 days. The CBSA is not obliged to provide reasons for the detention, and in my experience, they have not disclosed what aspect of the supply chain led to the decision to detain. Due to the nature and extent of information required, it may be a tremendous time and resource-intensive undertaking for importers to trace each step of production back to raw materials for every component or material in every product imported into Canada. Doing so may require documents that are not in the importer's possession and that they have no legal right or commercial leverage to be able to obtain. They may include records that importers do not presently have express legal obligations to maintain under current regulations. Now, some importers may reasonably be able to take steps to strengthen their contracts and require parties up the supply chain to provide information. But depending on the nature of the good and their business, they may not be able to establish a chain of custody traceable to the actual good imported, or afford a compliance program of the scale required to do so. Options for importers to formally mitigate their risk of enforcement action before an importer occurs are limited, since as a matter of policy, the CBSA will not issue advanced rulings for forced labor and child labor classification determinations. The importer bears all of the due diligence burden and the legal risk. Furthermore, the CBSA does not currently publicize the information or investigation reports that it uses to detain shipments. So let me conclude by saying that not giving importers a way to access information about which suppliers or supply chains are considered high risk, or to obtain guidance from the government, leaves Canadian importers with a significant information gap and undermines the policy goal of reducing forced labor and child labor worldwide. I appreciate that members of the committee are considering various solutions to those challenges. And I'll just say that if the government is going to introduce something like a presumption of denial entity list, it will be very important to create due process to allow stakeholders to provide information prior to listing, have the ability to appeal decisions, and to apply to be delisted, particularly if the listing is based on unproven allegations or circumstantial public source evidence. Thank you for the opportunity to appear before you, and I look forward to responding to your questions.
Thank you, Ms. Bandali. Mr. Pike, please.
Good afternoon, Madam Chair and members of the committee. It's an honor to have the opportunity to speak to you this afternoon and to answer your questions regarding Canadian supply chains, forced labor, and related imports. My evidence today, as my colleague had said, represents my own views, and I'm here as an individual and not representing my law firm, Gowling WLG, its clients, or any third parties. I'm a business lawyer based in Toronto and serve a wide variety of clients headquartered in Canada, the United States, Europe, and Asia. I've worked for more than 10 years on issues pertaining to forced labor and child labor in supply chains, going all the way back to a project I initiated in 2015 to draft model Canadian business principles on forced labor, labor trafficking, and illegal and harmful child labor with the Canadian Corporate Counsel Association, and those model Canadian business principles were adopted by the Canadian Bar Association in February 2016. In the next few minutes, I want to provide some important context that overshadows our evidence today. I'd like to speak briefly about forced labor and the scope of exploitation of people at the far end of supply chains, many with no way out. According to the International Labour Organization, the ILO, there are 27.6 million people trapped in forced labor that generate exploitation that results in something like 236 billion American dollars in profits every year. At the same time, there's nearly 138 million children suffering in child labor worldwide, 54 million of whom are in hazardous work likely to harm their health, their safety, and their morals. I'd like to say that, unfortunately, forced labor exploitation is being seen as a dynamic issue. For example, I'll draw your attention to a recent publication by the ILO pertaining to forced labor. Last month, on November 18th, the ILO published a revised edition of its 2012 advisory listing the indicators of forced labor. The revised edition adds a new provision in this exploitation through forced labor. It's a provision on state-imposed forced labor. State-imposed forced labor can take various forms, including compulsory labor as a form of political coercion or punishment for persons expressing political views or views opposed to the established political, social, and economic system. These indicators of forced labor are designed to support frontline actors such as the U.S. Customs and Border Protection in detecting potential victims of forced labor. For example, the CBP lists the relevant indicators of forced labor in every press release. It announces the issue of a withhold release order. I would be remiss if I didn't make reference to the Fighting Against Forced Labor and Child Labor in Supply Chains Act that, as you know, came into force on January 1, 2024. I note that the Supply Chains Act, with its inclusion of the amendment to the customs tariff to prohibit the importation into Canada of goods mined, manufactured, or produced in whole or in part with child labor, and its imposition of reporting requirements on federal government institutions is globally unique in its approach to addressing risks of what many call modern slavery. In my view, the steps taken by reporting entities to prevent the risk and prevent and reduce the risk of forced labor and child labor in supply chains and business operations, those steps have been disclosed in almost 11,500 reports filed in the first 2 years of the Supply Chain Act. And in my view, those steps may be impacting the fight against forced labor and child labor in supply chain in a very positive way. I'd be happy to discuss that further if you wish. Thank you very much for permitting me to provide my opening statement.
Thank you, Mr. Beck. Mr. Stephenson.
Madam Chair, and it's good afternoon to everyone here. It's a pleasure to be here with you today to talk about the very important issue of forced labor. Similar to my colleagues, I will be expressing my own views here. I am counsel at Dentons Canada LLP, and for the past 2 years I have chaired the Canadian Bars Association section of international law, and I have chaired their working group on modern slavery practices. I'm currently the past chair of that section. So that experience has informed my views, where I've been able to speak with lawyers throughout the country on this issue. I'm going to first off say that I agree with many of the comments made by my colleague Sabrina, who very thoroughly described the process and the issues, and I do not intend to revisit that. I think that's well established. But I will focus my presentation on a couple of different things. First, the existing prohibitions that we have, and second, the bill that has been tabled and some of the potential implications of that bill. So first, on the prohibition that we have, I'd like to talk about one, enforcement and transparency. I think this committee is well briefed on the CBSA's enforcement measures, and you have the numbers of enforcement. You also have, I think, discussed with the CBSA transparency. I think the numbers on enforcement speak for themselves. There's not been a particularly large amount of enforcement coming from the CBSA, and we don't have a real transparent view of what those numbers actually look like in real time, save for committee appearances like the ones that we had last week. On transparency and numbers, I would say that transparency can act as a method of deterrence. When importers know that the CBSA is actively looking at these types of issues, when those types of numbers are being made public, that is a form of deterrence, and that is a form of encouraging compliance. So I would encourage the committee to really take that to heart, because those are numbers that we are frequently asked as counsel. Has there been any detentions? And when we can say we don't have any knowledge of this, none of this is public, that does not help in terms of enforcement and compliance of these serious issues. Secondly, in relation to guidance, I think this committee is well aware that there has been guidance for forced labor that has been initially issued by the CBSA in 2021. We are still waiting for a final version of that guidance. The CBA Modern Slavery Working Group did make submissions to the Modern Slavery Task Force in January of last year, and we just simply never heard back. So engaging experts on these types of issues where we believe that we can significantly contribute, I think is an important point. On that point, I would note that for the Supply Chains Act, or Bill S211, we have had a different experience with Public Safety Canada. I would note that myself and my colleague Stephen are part of the external counsel panel that they have established. Essentially canvassed our views on this, and it's not only our views as individuals, but the views of a large amount of lawyers across the country, which has resulted, I believe, in positive achievements, which, particularly in a significantly revised guidance document from Public Safety Canada, which has addressed a lot of the concerns, both legal and practical, that the importing community has faced. So those were a few initial comments on the current state of the import ban. And now a couple of comments on the bill that has been proposed. I believe that is or C-251, which creates the reverse presumption. First and foremost, based on our experience with the Supply Chains Act, it is critical to have clarity in not only the law but in the guidance. This is one thing that we lacked when Bill S-211 became live. There was not significant guidance that addressed the concerns that the reporting community had. So to the extent the bill moves forward, I think that it needs to move forward with clarity and guidance. Our counterparts to the South have very clear guidance documentation of what is actually expected from importers. The documents that they need to have, the standards that they need to meet. The law is fine, I think, as written, but it needs to be supplemented with regulations or very clear guidance. There is an open question as to whether we need more legislation. I think Canada has a knack for potentially trying to legislate out of enforcement problems, but I will leave that open for the committee to discuss. And second of all, what would the impact potentially be of this type of bill? In my view, the impact would be potentially threefold. It would likely cause large importers to review their compliance and diligence functions. So that's potentially a good thing, where we'd have a little bit more internal policing from our large importers here in Canada. Many folks who import both into Canada and the United States have already gone through that process, but I think we would see that again here. Second of all, there would be a clear mandate for the CBSA to review additional shipments. So, those numbers of investigations would likely go up. Again, potentially a positive thing there. Third, I think we would need to consider the implications of the act or the potential act or the bill against Section 15 and Section 155 of the Customs Act, which has a positive obligation to disclose the fact that you have or might know of forced labor goods in your possession, and also if you have them in your possession, it can cause a penalty. So what does creating a presumption in law do to those obligations for not only importers, but people, regular Canadian businesses down the chain? I'll leave my comments there for now, but happy to take any questions.
Thank you all very much. Much appreciated. Mr. Manto for 6 minutes, please.
Thank you, Madam Chair. Thank you to our witnesses for appearing. We are all partisans around this table, but let no one say that I'm not actually interested in this issue. That's why we have sought out these experts here, who I will say are probably the most knowledgeable in Canada on these issues. So
already.
Yeah, very thankful for their testimony. I think we learned more from you three than we did from the CBSA. And that's part of the problem with this issue. In fact, I put Section 115 to the CBSA when they were here, and they had no answer for me on the obligation to, that it's a violation to possess goods, just have them in your possession that are illegally imported. They had no answer for that. But I want to pick up on the transparency issue with the process, because that's been raised by a lot of members. And of course, the natural comparison is the United States. You go on the CBP website, you can look up the dashboard, you can see how many shipments have been interdicted, what their value was, where they came from, generally what kind of products they were. You can download an Excel sheet and look at what entities are on the list. But it seems like that the CBSA is just allergic to this type of transparency. And so 2 questions is, what's your experience in getting information from the CBSA for your clients? Do we need more transparency from the CBSA? And do you have any recommendations that the committee might make on that issue to the House or to the agency itself? Whoever wants to start first, but I'd like to hear from each witness.
Go ahead. So as I mentioned in my remarks, in those detention situations, there was no disclosure of the reason for the detention or what information, what aspect of the supply chain was problematic. The difficulty I think that creates for importers is that you can't run in all directions all at the same time. And so having some information in order to be able to guide how you're going to devote your resources is very important. If my colleagues want to chime in first.
As a general matter, we have had difficulties obtaining information from the CBSA, and we are cognizant that there is obviously a lot of confidential data, for every particular importer. We are talking about, basic numbers of how many, you shouldn't have to file an access to information request to know how many shipments have been stopped. So broad numbers and things like that are helpful, and we do get those questions as council, not only what the law is, but importers do look at what is the risk, how much do we need to put into our compliance program, and having those types of numbers I think would be helpful to be able to share with our clients of saying it's being actively looked at, or they're not doing anything. There's a meaningful sort of risk gauge that I think a lot of clients go to when they're designing compliance programs.
I don't have anything to add to what my colleagues have said.
If I can just add one additional point, because you did ask about recommendations.
Yes. Mm-hmm.
I can appreciate the sensitivity of information and putting it out into the public domain. I think one of the things, or one of the difficulties when you highlight, for example, a geography, for a government to do so, it raises political considerations. I think that's well understood. But when you are in the situation of having your actual goods detained and you're being asked for information, to then not be able to have some disclosure of what gave rise to the concern so that you can focus your efforts in the supply chain to provide probative information in that context, I think that's problematic. And so if there was a recommendation to make, I think even confidential disclosure to affected importers would be very helpful.
Thank you. Yeah, I mean, the CBSA, of course, deals with confidential information all the time, and there are legal mechanisms to provide undertakings or protect that information, at least on a council basis. So thank you for that. You mentioned the D memo, departmental memorandum. I think it was 2021 it first emerged. Would it be helpful if the CBSA finished that review and issued some sort of guidance for clients? It's not a trick question.
Yes.
Okay.
Yes. I think that given the passage and the coming into force of what was S211, January 1, 2024, that added child labor to the forced labor tariff number, I think we'd want to get that in the D memo, because the memo right now doesn't refer to child labor.
And I think, again, if I can just add, it really comes down to the issue of focus. Importers right now don't have clarity on whether they are to focus on the diligence that they can do to their immediate counterparty. The good that's actually being imported into Canada is what is most important to make sure that that production activity is forced labor free. Or are all tiers of the supply chain equally important to the CBSA? So even having that clarity about what the policy is going to be from an enforcement perspective, the expectation, again, it's about being able to use resources wisely that are not unlimited.
Yeah, thank you. I just have 30 seconds left, but on that expectation point, I mean, it always seemed odd to me that we have this broad-based ban, which, it's the heaviest hammer you can use, complete importation ban, but no guidance on what that means, including if I have one bolt in my car that was made by forced labor, am I offside now? So like what they did with S211, where they sort of gave some more information about de minimis and things like that, would that type of information be helpful to include in the D memo?
Yes.
You have to say yes, so we get it on the record.
Yes, and again, like the CBA working group, we did make submissions that we thought would be helpful, at least from a council perspective. For the CBSA, they could, the intent was for them to take it into consideration. Here was our wish list. We might not get everything, but from a legal perspective, this is what importers are actually wanting.
Was that? Sorry, I know I'm over time. Was that for the Supply Chains Act or for the forced labor ban? That wish list.
That was for the forced labor ban.
Could you provide that to the committee?
The information that you had previously submitted. Yes. Okay, off to Mr. Navki for 6 minutes.
Thank you, Chair. Thank you to all the witnesses for appearing today. It's always good to have independent legal advice. So great to have you all. I'm not an expert in this issue, even though I practice international trade law, but this is not the area that I ever focused on. So I'm learning as I'm going through these hearings. Though from a public policy perspective, I do recognize that forced labor is an issue that we need to find a way to address. Though I'm also learning it's fairly complicated for all the compliance reasons that you have highlighted in your submissions. So let me ask you, as lawyers, we have opinions, and we do know if we were writing laws, how we would write it so that they actually work. If you were get to write laws dealing with tackling the issue of forced labor, what would be some key ingredients that you will make sure that's available, that's in the law, in the policy, that will allow for us, from a public policy perspective, deal with an odious practice, but do so in a way that is actually effective? Start with Ms. Bendali, with you.
I think civil enforcement is very important. And the reason for that is because, again, to the extent that this is a question of getting information about something that may be very far away from your own operations, I think anyone who's engaged in due diligence, certainly any lawyers who have engaged in due diligence, know you can go forever. And so having some sense, having a law that is drafted in a way to give people some sense of what the scope is of the legal obligation that falls on their shoulders, that then would result in legal consequences for them, be they civil, be they criminal. But I'd venture to say that in this context, civil is important. Civil is the appropriate mechanism, and tied to what is practical, what is reasonable, an appreciation of the fact that goods today, some goods are just tremendously complex, and the burden that puts on trade if people cannot trade in complex manufactured goods without having absolute traceability back to raw materials, it's an unrealistic standard.
Mr. Pike?
Thing I would include, as was included in the Supply Chains Act, was the participation of federal government institutions in terms of abiding by the same rules that the private sector is dealing with in terms of its procurement.
So I guess to step back a little bit, as a regulator, there are 3 buckets that we've seen globally being developed. So first is reporting legislation. We have that. Second is a trade ban. We have that. The third bucket, which we don't have in Canada, is due diligence. And Europe, certain European countries have gone that far. There may be diligence legislation, EU-wide diligence legislation coming down the pipe. But those are sort of the 3 regulatory buckets. We have 2 of those buckets. I think what we need to work on is strengthening our enforcement of those buckets. So, transparency at the CBSA, I think, would be great. Clarity and guidance would be great. Closing the information gaps that our regulators do have, that would be great. And looking at other trade programs. For example, in the U.S., they have a program called CIIT. It's the Customs Trade Partnership Against Terrorism. They have actually introduced, which essentially makes trusted importers. So you can go through with less, sort of past the border with less inspections. They've introduced forced labor requirements for those for those folks who are registered in those programs. We have not done the same. Canada has the PIP, or the Partners in Protection. We have not done the same. So there are still levers that I think we can pull without additional legislation.
In our previous testimony, I've asked a question as to what other jurisdiction we may look at that you may say has got it better or doing a finer job in dealing with the issue. Your thoughts on that? The answer we got was European Union probably have a set of laws or regulations that are superior than ours. Would you agree with that assessment? And if so, which elements of their rules and regulations makes it better that if we incorporate in our laws will improve our compliance as well?
characterize them as better. I characterize them as different. They have different and much different legal regimes than we have. And again, with the EU structure, it's a way to have a large number of countries collaborate together and ensure that they can move together within that union. So it's based on a due diligence regime and on reporting. And what we see in many of the other European laws, like the French Duty of Vigilance and the German Supply Chain Act, is we're seeing a very high threshold. So they're only talking about putting hundreds, 200, 300, 400, 500 companies, the biggest companies, to be covered by the Act. So it's not as widespread in terms of what you'd see in the Supply Chains Act, the Canadian Supply Chains Act. So it's really got a different target, and it really looking at the biggest companies in those jurisdictions and getting them to take on the compliance burden to comply with those laws. There is a significant compliance burden for businesses in all of these reporting regimes, including the Canada Supply Chain Act. But with respect to the European legislation, it's more intensive in terms of the requirements for companies, and that is something that is different than what we have, but something to be aware of if we're looking at regimes that are like the CIIT or other.
Thank you very much, sir. Thank you for the information. Monsieur Savard-Tremblay for 6 minutes, please.
Madame la Présidente.
Thank you, Madam Chair. Thank you to our witnesses for being here and for their presentations. Mr. Stevenson, I'll start with you because you mentioned the bill that I tabled, C-251. And I appreciate all the everything that you're saying. So if we're able to send it further, the committee will have the opportunity to see what can be improved. But I think that the fundamental intention, reversing the burden of proof, is good. So you seem to say that, yes, changing the act is good, but you said that we had to give the agency tools to do, and that these lists and guides be given all the time. But do you think that the intention makes good sense?
Way that you can proceed, and the United States has proceeded down that route, and you see results. That is paired with a very, I would say, intentional or aggressive enforcement strategy. So they have been well funded, they are well researched, and on the trade ban, globally, whether it's UFLPA or their other trade actions, they are probably the most sophisticated. So you could debate the merits of the law and whether or not that would, whether or not that's the right way to go. But with the law, I think you need proper guidance, so importers know what they're doing, and the CBSA also needs to be prepared for the consequences that will bring overall. And I think that's additional additional investigations, and then you're probably also going to have a potential change in CBSA policy. My colleague Sabrina mentioned that you can't get an advanced ruling for forced labor goods. Well, what happens to Section 15? What happens to Section 155, where all of a sudden a news article comes out that one of your suppliers has engaged in forced labor and you're holding that good in Canada now? What happens to you in that type of situation? Do you want to go get an advanced ruling from CBSA on the issue? So I think there's my primary concern is there's mechanics that need to be worked out in these types of situations.
Je vous entends, mais vous
I hear what you're saying, but you are saying that this would be a very efficient and robust law if we gave ourselves the means and the mechanics. Yes, it might be. certain. Thank you. Now, we know that 91% of the entities who declare things say they didn't detect any cases of forced labor, but 82% acknowledge that there are risks. It's almost as high a percentage as the other side. So how do you interpret that difference? Is it a problem with the methodology used to measure it, a problem with the investigative capacity, the reports that were filed? Yes. As an act, you don't need to worry. You just need to make a report of your efforts to combat forced labor in your supply chains. And at the same time, you have to say whether you observed something or not. But if you didn't see anything, you say, well, I didn't see it in my supply chain. But you don't need to ask the question. So that was the difference between these. That explains that data. I'm also going to ask Mr. Pike a question. You already stated that Canada was insufficiently applying the interdictions, the bans in CUSMA. So what do we have to put in place at the customs to be in compliance? We didn't inform Mr. Pike that there was interpretation before the beginning of the meeting? Well, we should have told you that you could listen to simultaneous translation. It should have been given. Oh, he has hearing aids. And so how do we proceed in that case? Close.
Est-ce que tu peux juste répéter la question?
Can you just repeat the question? We have to deal with the problem. Like to present a notice of motion. Thank you. but I would like to take advantage to do that. I will have time to distribute it to you. We don't need to decide right away, and I'm also ready to changing the way it's drafted. I'll read it for you, and it will be distributed to you in a minute. Considering that the government announced in its March 2023 budget and repeated in 2024 its intention to file before the end of the year, that year, a bill aiming to eliminate forced labor from Canadian supply chain and reinvents the banning of goods produced by forced labor. Given that engagement was not renewed in the 2025 budget and up to now, no bill from the government has been present to that effect, that the committee make a report to the House to lament the fact that the government has not acted in such a manner, and that the committee asks an answer from the government pursuant to Standing Order 109. I'll give it to the clerk so that he can distribute it.
Dépendamment de s'ils sont prêts à voter. Vous seriez prêt à voter? On va leur laisser un peu de temps.
Some discussion, right? Okay. Right, so...
Voulez-vous suspendre quelques minutes?
Well, we are suspended because I suspended for you to get your time.
came back in to do
and
this.
then went back in. Okay. Here while we read this, okay? Meeting back to order. And we have an agreement with this motion that we will deal with this when we come back in January. Mr. Fonseca.
Very quick. So it's about, this motion is that the Committee of International Trade undertake a study of no fewer than 3 meetings on the subject of the
It's on the list.
potential.
He can move his motion when it's his point of order. He can move his motion when it's his speaking slot. I'm next. I have 5 minutes. We have 3 minutes left in the committee, so that will be the end of it. You can put it on written notice.
Well, we were trying to be efficient with our time, but seeing the time it is, I'm just going to adjourn the meeting, period. Okay? Meeting adjourned.